stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome to the show. I am your host, Daniel. I'm sorry I'm a little late. I had to wait for the office to open so I could pay my rent. Today is Judge Simpson, another one of my favorite judges. So let's get started. Yes, I'm here and I will be watching. I will have my mic muted. So let's get started.
Court does call the case of the people versus James Whitley.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm hearing with and on behalf of James Dennis Whitley.
This is people's emergency motion to modify violence in this case.
I find it surprising that they're alleging that she's in danger, the prosecutor. They don't call her to show up. She reached out to a friend of my client
Call her to show to do what?
today to say, I'm afraid. I mean, I will say,
Mr. Bennett, you've been doing this long enough. You know that's not going to happen.
I don't know, at 3 o'clock with 24 hours notice, I couldn't have got a hearing in that.
Could have got a hearing on what?
If this was reversed.
Absolutely. Oh, do not even insult this court by saying that, Mr. Bennett. Do not, because you would have gotten a hearing. Had you filed a motion, had you requested that it is an emergency hearing, the public defender's office does it all the time. The fact you don't know how to do that and think that this court is playing favorites, you're wrong. Court's going to stand in recess.
Right. Have you seen it? 14A District Court, County, Washington. Session, the Honorable Judge J Cedic Simpson. But
You may be seated. Court recalls the case of the People versus Whitman.
Good afternoon, Your Honor. For the record, my name is Judge Bennett. I'm here to do on behalf of Mr. Woodley Estate to my right. Woodley, can you state your name before, please? James Estate.
Let me just say this, Mr. Bennett. I've been on this bench almost 25 years, and never have I ever been insulted in the fashion you just insulted this court. No, my turn. The very first case, when you say that defense counsel or anybody else doesn't get access to the court like the prosecutors, you are absolutely wrong. The first case I called today was upon receiving a notification about something that I had considered in a bond, was notified that that had been located. This court, to the defendant's benefit, set that hearing without notice to any side. I set the hearing. So to be fair to all of the parties, I receive motions all the time regarding bond. And this court just seeks to be fair, to have a hearing. Mr. Bennett, if I had had in my heart the desire just to lock your client up, quite frankly, because the decision came from a magistrate under the court rule without a hearing, I could have changed that bond. But I wanted to give the parties the opportunity to be heard. Now, having said that, so maybe you can put that in a little perspective. I heard you that you said you just got the discovery, can't go through it. Well, I'm going to give you about another 18 hours to go through it because I'm adjourning this hearing for two reasons. To allow you to go through the discovery, to give me a cogent argument as to why I should not grant what the people want. And secondly, because you have raised the ire of this court. I am not going to punish your client by what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not, by any means, punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow, May 10th, noon. All the parties are ordered to be here. That is all. That is all. Noon tomorrow. All right. They're bringing him. Don't talk to him. Court calls the case People versus Thomas Styron.
I'm Stein, the living man. I'm here by special appearance to address this matter.
I'm sorry.
So I'm Thomas Styron, the living man, not Thomas Gilbert Styron, the entity you know me as, or as I'm in my papers. I'm here to address the matter.
All right. Thank you. Wish to be represented by an attorney, sir?
No, I'm here to address the appropriate persona.
All right. I do have to advise, so you're gonna represent, you need to stand in the middle of the podium where he's telling you to stand. Now. Mr. Allen. If you don't want to cooperate and
I'm
handle
at the
things,
podium.
he wanted you in the middle of the podium where you're supposed to be. If you don't want to be there, then say no. I'm telling you now to do it.
If you want me to stand close to the mic, no problem.
Sir, you want to play a game with me?
No.
Not today. Mr. Allen, take him. We'll bring him back out when he wants to cooperate. Yeah, I need an interpreter for the last two and that one.
May I swear the interpreter?
Yes, is it for the last two cases?
Yes.
Yeah, that one we'll swear in.
For interpreter, you're in front of the Honorable J Cedic Simpson out of the 14th District Court of Washington County, State of Michigan. Our number is 1.
Get somebody from security to check back there.
She's got a shirt on. So I'll take it up. So I'll deal with him. I'll take the cuffs off. Get it out.
I don't know that we're gonna be doing all that, but let me ask you something. On the Styron matter, I sent my bailiff back to get him to bring him back out. The court is of the understanding that defendant number one is being, I will say, uncooperative, has purposely done some things to make it difficult to bring him out. What I'm going to do at this point in time, we're not going to wait and not going to play his game. We will hear him next week because of his behavior today before the court. At this point, I will revoke his bond and I will adjourn the probable cause conference. He certainly poses a risk to even bring him out. So I will adjourn this out to May 2nd, 2024, 9 a.m. or as the invite indicates. I will leave it there for the reasons that I've stated on the record. Mr. Mansour, he is not represented by counsel. If you would, for the court, take the opportunity to go back and to apprise him that of what the court has done and that I will see him next week. The court feeling that he's being uncooperative and not compliant. All right. Thank you.
Thank you, Your Honor.
Thank you.
Taxes was chasing.
Court does call the case, People versus Tariq Day.
I am Tariq Samaritari Day, the executor of the Tariq Samaritari Day Living Trust and the registered owner of the Tariq Samaritari Day Ex Relatione Kingdom Wilson Estate.
Right. So you are appearing here without an attorney. I do have to advise you that you are charged with the offense of fleeing and eluding in the 3rd degree under the Motor Vehicle Code. That is a felony punishable by up to 5 years incarceration and or a $1,000 fine plus court costs. Additionally, the Secretary of State could suspend your driving privileges for up to a year. Do you understand that, sir?
I comprehend.
Do you understand?
I comprehend, yes.
The court has to further advise you that if you wish to be represented by counsel, the court would ensure that counsel would be appointed to represent you in this matter and that you would have counsel if you could not afford to hire counsel yourself. I also wish to advise you that the court would be treating you the same as it would the people in this case. There are certain dangers to representing yourself in this matter, in that you will be required to abide by the Michigan court rules
the Michigan Rules of Evidence and all of the cases and statutory requirements. You understand that?
I do not.
You do not. What is it about that that you do not understand?
It's against my religion to adhere or to assimilate to any statutory.
Sir, I'm not asking anything about your religion. It is irrelevant to me. I am indicating that in this proceeding, you will be required to abide by the rules of this court. Do you understand that?
I'm having a hard time understanding why or how religion doesn't play a role. If
How what?
how religion does not play a role.
Religion does not play a role in what I do or what this court does. There are certain rules of this court established by the legislature and the Michigan Supreme Court regarding how these particular proceedings will be conducted. These proceedings will be conducted in accord with those rules. Do you understand that, sir?
Well, according to the American Declaration on the Rights of Indigenous Peoples, as well as the international or the United Nations Declaration on the Rights of Indigenous Peoples, the state and the governments should.
Sir, you have no authority for what you're about to state because what you're about to state is incorrect.
Oh, I am an Indigenous person.
No,
So I do have.
sir, what you're about to state is incorrect.
Well,
If you were on indigenous lands, if that's where you're going, then maybe you might be right. As it stands right now, this proceeding is not on indigenous land.
well, that's a matter of perspective, sir.
It is, and the only perspective that's going to matter on that is mine. We are not on indigenous lands subject to indigenous or tribal rules.
Is there
You
a
are
law?
subject to the rules of the Michigan Supreme Court as they are promulgated, both in terms of procedure and evidence. Do you understand that that's what's happening, sir?
I do not.
What is it that you do not understand?
I don't understand.
Because I'm going to tell you something, sir. If you are unable to establish or understand what I'm saying, and go through this with you again, I have to assume that there may be some reason why you don't understand. This court will take precautions to protect your rights, and I will be sending you for a competency evaluation to make sure that you are competent to stand trial and to stand in these proceedings.
Well, I would agree to a competency if the prosecution as well as the court and the officers agree to take a competency.
That's not the way it works. You don't get to make the rules.
I'm not.
I'm ordering a competency.
I'm not making.
Defendant is ordered for a forensic evaluation. I will set a competency hearing in this matter for July 25th, 2024. At what time? At 9 a.m. Now, sir, I'm going to ask you this.
Yes, sir.
Because it's going to depend on where you may be staying for a period of time.
After a car wreck,
If they send you information as to when you have your forensic interview,
Yes, sir.
are you going to cooperate and attend that interview?
Under threat, duress, and coercion. Yes.
Pardon?
Under threat, duress, and coercion. Yes.
No. It's not how it works.
I don't.
I'm asking you, are you voluntarily going to cooperate?
I say yes.
Pardon?
I mean, under it, yeah. I mean, is this what are, excuse me, what are you relaying to in regard? What are you insinuating in regards to where I will stay for a time.
I'm going to make sure that we are going to have our forensic interview done. I've ordered a forensic interview. I am asking you whether or not, when given notice of that interview, whether or not you are going to voluntarily cooperate in that interview.
I will take the interview.
Excuse me?
I will take the interview.
Anything from the people?
The court ask the people to prepare the order for the competency.
Yes, please prepare the order for the competency if you would, sir.
And the address for,
The defendant,
I see on the complaint is 14.
is that your address, sir?
Excuse me? Yeah, that's correct.
All right, very good.
And so I will send a copy to that address.
Very good. All right. This time then bond is continued.
Yes, sir. And I'm sorry, can I get that date again, please, sir? If I can put it in my calendar.
July 25th, you were supposed to, so I'm assuming you're waiving it. You were supposed to file your motion with.
I
the
did,
court.
I filed it.
When did you file it?
I brought it in today.
Do we have it?
I gave it, I mean, it was stamped and everything. I gave it to the reception.
Why didn't you file it before today?
Well, as I stated at the last hearing,
No, don't go through what you
additional week.
stated at the last hearing.
Well, you
You
asked.
knew that, no, you knew it was supposed to be filed before the day. Young man, you're gonna
That's it.
figure out something. We're playing by my rules, not yours. So you know, do not say anything because you're gonna figure that out real soon. Do they have it?
I have not received a response yet.
Since I'm sending in for a competency, I can't hear that. I can't hear his motion in any event. So I won't hear his motion at this time. He'll have to refile it timely if he's determined to be competent. So I'll have his bond continue. He can go. What?
I didn't get the last part that you said. The bond continued and what?
I said you can go.
Oh, okay, no problem.
Is that it for me? Thank you, Ann. Thank you, Alan. Thank you, Em. 14A.
And Washtenaw was not going to release him because they were concerned that a tether was going to be cut off, which inevitably, after Wayne County promised they wouldn't cut it off, ended up cutting it off.
Cutting off.
The Washtenaw County tether.
Who did? Let's call the case. The people state of Michigan versus Ali Abakur.
Good afternoon again, Your Honor. Hassan Mahdi on behalf of Ali Abakur. It's approaching. State your name for the record, please.
Ali Abakur.
Your Honor, well, at this time, we're going to be asking for a preliminary examination.
Okay, I will be more than happy to set a preliminary examination. Also, counsel, did you?
I did.
The modification of the bond. Deal with that.
Your Honor, I did.
Oh, you saw it, okay. Would everybody be ready on the 10th? Or you would?
May I check my calendar, Judge?
Sure.
I have high IQ. Why do I forget what I've just read before I even finish the page?
Yes, Your Honor.
That'll work. Preliminary examination be in person. September 10th 2024, 9 a.m. before Judge Burke.
Is that time going to change or that?
No, that time is firm, that 9 a.m. time.
Thank you, Your Honor.
As to bond.
Your Honor, I laid it out, I think, pretty clearly in the motion. At this point, we are requesting an increase in the defendant's bond based on his non-compliance with surrendering the weapons. I have had conversations with defense counsel between yesterday and today. He has assured me that there is no AR-15 in his possession or otherwise. However, there are other registered weapons to the defendant which have yet to be surrendered. We are in the process of facilitating to have those be surrendered. However, they have not yet been surrendered.
If I may, Your Honor.
Yeah, well, I just want to clarify one thing. He wasn't on the Wayne County matter. He was not arraigned
When the offense occurred.
when this offense occurred.
Correct. It went Wayne County case, the conduct.
Okay.
Washtenaw County case conduct, Wayne County case arraignment, Washtenaw County case arraignment.
Allegedly. Conduct allegedly.
Understood.
Thank you.
But I guess what I was trying to figure out, so the magistrate in setting the bond, you believe, took into account the Wayne County conditions.
I am not certain of that. Your Honor is not the one who handled that arraignment or wrote the bond. So I cannot attest to what was said on the record.
I can speak to that.
Go ahead.
So this court knows Wayne County not only put him on a tether, but also home confinement. And Wayne County, obviously, through all their cases, when somebody's charged with a felony, is not in possession of any firearms, which at that point, Mr. Abu Kuder was not in possession, and to this day has never been in possession of any firearms after the bond. Now, that being said, I take full accountability for, and when I say I'm saying counsel, for him not turning in those guns, or gun, or whatever's at the home that we said to the prosecutor they're at. But he is nowhere near that home. He has to be confined to his mother's house, which he's been since day one, since he's left. What I could tell the court is we had many issues with both Washtenaw and Wayne. Why? He has two tethers on his ankles, one on each ankle. And Washtenaw was not going to release him because they were concerned that a tether was going to be cut off, which inevitably, after Wayne County promised they wouldn't cut it off, ended up cutting it off.
Cutting off
The Washtenaw County tether.
who did?
The Wayne County Sheriff's Department. So, but then they fixed the tether, and then eventually a day later, they released him with two tethers. So it was a big mess. We were trying to get him out. I had discussed with my client this rifle that was, and I believe, a lethality, or one of the reports that the allegation that the victim said. He said he's not aware of that. He doesn't have that. I left it at that. It's my fault. Registered guns should have been turned over 24 hours after release. He didn't do that. We are not willing. We are going to do that. I've sent the email to the prosecutor, an email stating this is the address that they're at. If you want, Ann Arbor Police Department can come pick them up. We have no issues. We're at the court's mercy. We apologize. I know I'm talking too much, but I want you to know, Judge, it was very difficult getting him out. He definitely doesn't want to go back in. We agree he should have turned in the guns. I'm taking accountability. The guns will be turned over, or guns turned over to the Ann Arbor Police Department. Your Honor, he has not stepped foot outside of that home, other than today, actually, after he was released.
Where are the weapons?
At his sister's house in Detroit. He's confined to his mother's home in Dearborn. And another issue that this court should be aware of.
Hold it. So I thought he lived in Redford.
He lives in Detroit, which is next to Redford, correct?
Correct.
Okay, so it's actually.
I know that.
Well, no, I mean, it has a Detroit zip code.
Redford leases it to Detroit.
Okay, whatever. Redford leases it to Detroit. But anyway, so yes, it's Detroit address. 2 blocks away from that address, which currently the alleged victim actually stays at, his home in Detroit. 2 blocks away from that is his sister's home, right? He's nowhere near any of that, and he's all the way in Dearborn with his mother, where he's been since he's left the Wayne County Jail. And he's confined to that home. Now, I don't want to give you my opinion.
But hold on, I'm trying to figure out, why are the weapons at his sister's house?
Well, I can approach on that end. I don't want to say it on the record, but they were not taken to his sister's house during the Wayne County or Washtenaw counties.
You don't know what an AI work management platform is? Yikes.
The Washtenaw County case. They were not taken. They're there, Judge. That's
okay.
They were there prior.
How many weapons are we talking?
1 or 2?
Two. Is that what you have when it comes back that there are 2 weapons? I mean, I realize there's the AR.
Information from Detective DeMille at Ann Arbor is that he has 2 registered pistols to him. We also noted that the victim noted to Ann Arbor police that he either had access to an AR-15 or had an AR-15 in his possession. Detective DeMille noted that you do not legally have to or required to register an AR-15. So the fact that it is not registered does not mean that he does not have one.
Your Honor, may I approach briefly?
Yes, you may.
Thank you.
I mean, well, before you do, so here's what I'm trying to figure out. There's that, certainly there's that condition. There may have been delays in getting him out and all those other things. I'm trying to figure out, as we speak right now, why those weapons are not in the possession of AAPD. And that's what I'm trying to figure out. And I appreciate you, counsel, taking responsibility for it. But certainly the sister, if that's where they are, could have gotten those weapons and turned them over to AAPD.
She could have. But I know where I guess I know where the court is going with this.
Oh, maybe, because I can change directions in a minute.
No, I get it. And they should have been. I don't know what to tell the court. They should have been turned over. The reality is it was a mishap, not just on, I don't want to blame him alone. It was on my end. We were more concerned about getting him out.
I understand what counsel's concern is in getting him out.
Yeah.
But the defendant knows he's not supposed to be, particularly given the nature of the charges, he's not supposed to be possessing any firearms.
Which he didn't.
Right. But he was also to turn those over. And I'm trying to figure out between the time of arraignment and as we sit here today, particularly given the fact that they're at this 3rd location, why Ann Arbor PD doesn't have those weapons now.
Now you're correct. They should have been. But what I want to indicate to her, this 3rd location, they've been at that location before he was arraigned, before the Wayne County arraignment. That's my point.
Okay. Sorry. My point is this.
They should.
At some point, counsel gets the motion. At some point,
yesterday,
you two are having some conversation. I'm trying to figure out, particularly if his liberty is in jeopardy, why I don't have those guns now.
Oh, I got the motion yesterday. I wasn't even aware of this. Honestly, just kind of slipped our mind about these guns, the bond that Magistrate Fink had put about the guns being turned over. My point is, as soon as Sister Counsel sent me the email, I called her, I sent her a follow-up email, talked to my client, actually sent her a follow-up email and told her, here's where the guns are. Can you have Ann Arbor Police Department go pick them up? And that was the last that we conversed about that.
That is all correct, but I will say I am concerned because counsel even noted on the record earlier that Wayne County also orders as a standard condition in all of their cases, no firearms.
No,
So that would be 2 cases where he's not in compliance.
Well, I don't want to put words in my mouth. I did not say Wayne County does the same thing by saying you cannot be in possession of any firearms. Magistrate Fink actually went a step further and said you have to turn them over to Ann Arbor Police Department. Wayne County did not do that and did not ask for that, just for the record. And at that point, I didn't know he had any firearms anyway.
Okay. I want the guns. I mean, for me, that's the bottom line. I mean, I'm worried about this AR-15 issue, but it's probably more of a national phenomena that we got to kind of deal with in terms of that and the registration. So I get that. But the ones that are registered to him, I'm trying to figure out why they didn't travel with you guys or with somebody down here today to get them to Ann Arbor.
Well, Your Honor, that's another thing. And Madam Prosecutor, I guess we don't know each other, but I did come here this today early and I told her somebody would have dropped them off like before court. And then she had indicated to me she was going to confirm with the police department on whether they wanted to pick them up or I just have somebody come before we were even in front of you to drop them off. And that was the last we spoke.
And before court was after the morning docket started, so I have not had an opportunity.
To check.
Correct.
I mean, I had no problem. The email was sent yesterday, last night, if Ann Arbor Police Department wanted to pick up the guns. Your Honor, I will tell the court this. They will be
Who? Okay.
They will be here today. I mean, they'll go straight to Ann Arbor Police Department right now. I'll call whoever family members can go pick them up and
I want the guns.
we're going to get the guns too.
Oh, I know.
Oh.
And so I need confirmation that those guns, that Ann Arbor will take them. Well, I know they will. I'm not, that's not going to be a problem. If they show up at AAPD, they're going to take them.
Right.
So I need those guns here before he leaves here. If I don't have the guns, he's not leaving.
We'll do that now.
Okay, let's go do that. I'm gonna pass the matter and let Ann Arbor know that they're on their way. You go call whoever you gotta call. They gotta get down here.
Got it. Thank you.
It's in recess. Oh, it'll be a short day. Oh, yeah, get up. Okay, bye.
Has Kyra texted you back?
Every day in the USA, people find themselves in court.
Given the circumstances, at least as I understand them, and because I haven't heard the entirety of the case or anything.
Right, exactly.
I'm
Probably was or anything.
going to deny your request. Bond, continue.
Why?
Excuse me? Excuse me? Sir, we're going to have a real problem if you're going to act like that in this court. I want to make it real clear. I understand you want to represent yourself. I told you I'm going to hold you to the same standards. You will not, by motion, by anything you say, disrespect anything in this court. You understand me? If there is another outburst during any of these proceedings like that in regard to my rulings, I will give you a place to stay. You do not have to worry about having a tether. Am I clear? Am I clear?
Sure.
That concludes this hearing. Set a bond violation hearing
April 16th, 2024 at 2 p.m.
Mhm.
At 2 p.m. Is there anything further, sir?
With the bond, yeah, that'll all be discussed as part of the tether condition. Because this time, this will be 10 days, it'll be like 15 days, and by the time that happens, I was hoping that would count for something, as far as the conditions of my bond. Maybe, yeah, I can't afford cash bonds or something, just a regular PR bond, maybe time that I've got it, you know.
I don't know what you're asking me.
If the tether situation could be addressed on the same day.
I'm going to address everything on any day that you appear. So if the tether is part of the condition of your bond, which at this point you're in violation of, I've set a hearing for the 16th to determine whether or not there was a violation. But the allegations are there that there was a violation. The following week, you're set for preliminary examination on the charges. Okay, so all right. I'm going to assume that there's nothing else. Bond will remain revoked. You wanted to argue your bond, sir, given the violation. How can you assure the court that you will abide by the conditions that have been set?
Just the fact that I'm a law-abiding citizen, besides the fact that I'm guilty of this, no proof that I haven't been guilty of it. Besides this ongoing I'm a law-abiding citizen, so I just ask for being considered innocent.
Sir, you are considered innocent until proven guilty, but the court also has the ability to set your bond and give conditions. All right. The court initially did that and you violated those conditions.
Yeah, no, I understand what you're, I think a lot, I do my best when I get out. That's when I get out, I'm a law-abiding citizen, I do.
It's 2 events that he's back at the library. So when I was speaking with the officer beforehand, he made that abundantly clear to me.
That there were 2 times that he was, yes.
That at 2 separate libraries.
So there's this filter thing and we're trying to figure out where it comes from. We'll sort that out. But the balloons are pretty, okay? They were. Okay.
So it's 2 April 3rd at 5:55 p.m. He was there. He was looking at according to the police report, he was looking at pornography at a public computer that he was suspected of masturbating. I asked the officer who's here to give me additional details about that. And I believe the information I got was that the witnesses believed he was masturbating, perhaps that his pants were in a certain position, that he was rubbing his genitalia underneath his clothes, which is similar to the events of the April 5th in the sense that when the police get there, he's not actually exposed, but certainly conducting himself in a way where he's got his chest exposed, his outer layer of pants pulled down. And this is a CSC case. So it's like, well, we take that behavior and then we layer it on with the fact that he's out on bond for assaulting nurses at the U of M hospital, and he's now charged with CSC for his sexual assaults on them. But in response to the I'm a law-abiding citizen, I mean, I'm looking at his criminal history from Florida, I'm looking at his criminal history from North Carolina, I'm looking at his criminal history from Michigan. The majority of what I'm seeing are misdemeanors, but I do have carrying a concealed weapon from North Carolina. There are larceny offenses from North Carolina. And well, there are. I'm not looking at them right now.
Sir, hold on. I will. The bond violation has been found and the defendant's bond will continue as revoked. You were set for, I will review that again, but you're set for preliminary examination in this matter this upcoming Tuesday, the 23rd, so a week from today. Pardon?
Doing my bond on that day.
I will look at it after I hear testimony in the case.
If you only do one thing to kick off 2026, let it be this. 9 to 5.
But at this point, your bond will continue as revoked.
Court calls case People versus Cody Lee Jolly.
I'm sure there's a praying on behalf of people.
Mr. Jolly?
Jolly, you're on in front of the judge.
Mr. Jolly? He is not responding. What are the people intending on doing this? He was found competent. I mean,
He was found competent.
Yes.
Yeah, I thought you said incompetent. Sorry.
No.
That's the tenor of my voice. What I can communicate, Your Honor, Mr. Jolly also has a case pending in the 15th District Court.
So you want me to send this here? No, go ahead. I'm sorry.
And I believe I was speaking with the prosecutor handling that case earlier this week. I think the intention is potentially to file a petition in both cases.
Got it.
Mr. Jolly. So why don't we kick this out a couple of weeks and I'll see if I can have that done by then, because I'm kind of at a loss of what else to do.
What else to do with it? Because he's not responding, didn't come up, and Joe has been kind enough to provide video for it. So what I will do, March 27th, 2025. The court does call the case of the People's State of Michigan versus Cody Lee Jolly.
Andrew Childers appearing on behalf of the people, Your Honor.
All right. And this is the date that has been set for preliminary examination. Mr. Jolly, you are there. Would you like to participate in this preliminary examination, sir? You are still entitled to do so. Okay, very good. Okay, I see the jury, and I was just about to mention what you sent me, but we're not at that stage. So what I'm trying to ask you is, do you want to participate in this proceeding today? You do. Okay. So you may have some questions yourself for the witness. You're muted at this time. Let me see if they can unmute you. Can you hear me, Mr. Jolly? Okay, so you might have some questions yourself. Okay. Okay, so we're going to go ahead with the preliminary examination momentarily. Let me just say something else. I received, and I don't know that I sent them off to the people, but I received on yesterday 2 letters, communications from Mr. Jolly. He said he sent a copy to the prosecutor's office.
I was going to say, Your Honor, I received a Teams message this morning from Miss Purdue, Tammy Purdue from our office, that we did receive those in the mail this morning. They hadn't been uploaded to the file yet, but there was a demand for jury trial and request for speedy trial.
Yes, so that is what I received, and a 12-person jury trial rather than a 6-person jury trial, if possible. That would, if this case is bound over, be will be dealt with by Judge Slay in that. And further, I would indicate that the delays in these proceedings, and I'm not trying to blame anybody for it necessarily, but the delays in these proceedings are really attributable to the defendant, given that he wished not to participate or come up and participate in the proceedings. So this is the exam.
Your day-to-day covered. With Phase 44.
Mr. Jolly, I do also have to inform you, since you are representing yourself, and I've advised you previously of the perils of representing yourself, and that it can be fraught with some difficulty.
You are charged with the offense of assault on an employee or a prison employee or an employee of a place of confinement. You do understand that charge, sir, correct? All right. That is a felony punishable by up to 5 years incarceration and a $2,500 fine plus court costs. You understand that, sir? All right. You're here representing yourself. You'll be held to the same standards as I would hold an attorney. I will not show you any favoritism or anything along those lines. You will be presumed to understand court procedure and the rules. You understand that, sir? All right. So you are also entitled to be represented by counsel. And if you make the request of the court to be represented by counsel at any point in the proceeding, the court will have an attorney to represent you. So, Mr. Jolly, I will ask you now, prior to us proceeding, do you wish to be represented by an attorney on this, sir? Okay, you want to proceed still on your own? And you understand my admonition or my caution to you? You understand that, sir? All right, very good. And we'll proceed.
And Your Honor, just a couple things for the sake of the record. Obviously, we're recording this. I know there's a video and we're all looking at it. But other than the question about having a counsel, the defendant nodded affirmatively to all of the court's questions. He then nodded in the negative with response to requesting an attorney. I just want to make sure that the record is clear to that.
Yes, and that is what the court's understanding.
And I would just further add, when we were last up on June the 26th and this matter was set for an exam, I did advise the court that a fresh or a clean copy of all of the police reports would be sent via interdepartmental mail to the defendant in the jail. And I did do that. I believe it was the following week, but that was sent in the interdepartmental mail by myself. A clean copy to Mr. Jolly. I just want the record to be clear as to that effect as well.
All right. And you received that, Mr. Jolly? So have you received any of the police reports in this case? So you've not received any of the evidence or anything like that? Okay, you put your hands up. Does that mean you don't know if you received it or you did not? Okay, let's do it this way, because you're nodding and you're using your head to respond to my questions. So I'll ask it really simple. Did you receive any of the discovery of police reports? All right, you're shaking your head no. So you have no information regarding this case? Okay, okay.
For what it's worth, Your Honor, when I actually spoke with Miss Kyriak and Ruli from the Public Defender's Office and asked her if I'm going to send something to an inmate, can I do it via interdepartmental mail? And what she told me was yes, put WCJ on the letters that we send throughout the department with the inmate's name, and it should get there. And that's what I did.
And I'm not familiar enough with this process, but is there a way to track whether or not it's been received and delivered to the inmate? Mr. Allen, are you aware of that?
There's two bail.
Pardon?
Bail visiting officer, whoever does that, they would know. Up front.
Okay. Mr. Jolly, if I, rather than do this by Zoom, if I give a new date.
Hey, wait. I need you to show me how to convert a Word doc to
or Lieutenant Arnett or someone and hand deliver it to them and have them hand deliver it to Mr. Jolly. And I could even prepare a proof of service.
Correct.
To that effect.
That's the part that I was thinking, so that he could do that. Yes, I see your indication of a speedy trial, but I also have to make sure that it is fair. So that is why I hesitate in proceeding today. So what I'm gonna do, give me my earliest day after it's the 4th. Who do I have on the 4th?
On the 4th,
That's where I sat.
that's where you set Pelfrey's 5 cases. Anyone?
And I know we also are here on Mr. Franklin on the 11th at 1 o'clock. I don't expect that to take longer than
Franklin.
Mr. Franklin is probably an hour and a half, 2 hours maximum in total.
All right, but we said that was in the afternoon.
That was in the afternoon on the 11th.
Because I have jury selection if I pick one.
Because we had jury selection only. Jury before that.
Okay, so what would, just to get everybody's input, I don't know where Mr. Jolly will be. Sir, would the 4th or the 11th be better for you? And I apologize.
Either or.
Either or.
Would they both be in the afternoon or morning or either or?
So on the 4th, we've got those
5 in the morning, but I do this first if we put it there.
That, I mean, correct me if I'm wrong, Mr. Apple, but if we did it first thing in the morning on the 4th, would that be better? Because you get off work at 7 a.m.?
Yeah.
Let's do that then. All right, the discovery packet will be delivered. We'll make sure of that. We'll have a proof of service. I'll adjourn this to my next available date, the preliminary examination. I will adjourn it to August 4th, 2025, 9 a.m. for me. And again, my apologies to the witness, Mr. Apple, in this case. I did not anticipate.
And again, just so the record is clear, is the court finding good cause for this adjournment?
Yes, I am adjourning this, finding good cause, because the defendant at least is indicating that he does not have discovery, although I believe it was sound. I can't verify that it was true.
And I will work with jail staff to ensure that it is hand delivered along with the proof of service, which I will send to the court once I receive it back.
All right, very good. Thank you, folks. Thank you, Mr. Jolly. I see your indication. 14A stands in.
If you're willing to learn how to use a free
State your name.
Daniel Magoo.
All right. What are we doing on this today?
Your Honor, I have in regards to case number 25F4-523. I have a couple things I'd like to point out about a couple of the matters here today.
Go ahead.
In regards to count 3, MCL 750197, lawfully detained or imprisoned in jail or confinement. Judging by the definition of the statute itself, Your Honor, it compels us to conclude that one has to be lawfully imprisoned or in jail. Jail being a facility operated by a local unit of government for detention of persons charged. At this location, defendant was located in a hospital and not a confinement by government agency or jail. So I'm requesting that that charge is invalid on
That were
its
going to
face.
be addressed, that would be addressed at a preliminary examination, sir, as to the sufficiency of the charge. So if you're making a motion that I dismiss it at this point, that motion's denied.
Okay. Further in count 2 and count 1, actually, Your Honor, both of these were, I don't know the procedural process or when it should get raised, but both of them are Fourth Amendment violations. And furthermore, on count 2, MCL 257.904, that the license of the defendant was revoked or suspended, given the statute as well, Your Honor. That would require the prosecutor to prove that the license was revoked or suspended at the time of the arrest, and that defendant was notified, and that the defendant operated a vehicle on a highway or roadway. I challenged the prosecutor to prove all three.
Sir,
Yes,
you
sir.
wish to have a preliminary examination in this?
I'm making sure we're prepared for it, but yes.
What'd you say?
Making sure we're prepared for it, but yes, I am. What are the other options? I'm requesting that all the charges are dismissed, a motion for all dismissal on all these charges.
They're not going to be dismissed.
No, okay.
So if you want a preliminary examination and make your arguments, then it might be that they would be dismissed at that point, but they're not going to be dismissed on an oral motion before this.
Okay, Ms. Lobby has let me know that all paper discovery has been sent to Mr. McGowan in jail. There are USB drives with video. A number of agencies were involved in the Michigan State Police case, so they responded to assist. I believe she has obtained all of those videos, and those will be sent interdepartmental to jail staff to serve on Mr. McGowan, and I expect those to be in the interdepartmental mail tomorrow.
Got it. Okay, so we're not ready. He hasn't gotten the video.
He has all paper discovery, but he does not have all video discovery. I expect that'll happen. So I'm not sure.
So, Mr. McGowan, are you going to have an objection to an adjournment so that you can see all of the discovery that they have prior to setting this for preliminary examination?
Your Honor, I didn't know what hearing I was prepared for today. I was preparing to cross-examine the officers today, with or without the video evidence. So given that that's not the case and the officers are not here, I would like a speedy trial. I would like to invoke my right to a speedy trial.
So you want your preliminary examination. Those are coming down to the jail to him?
I expect that you would have them early next week, so if the court follows its normal setting for preliminary examination, I would expect.
I would set it for the 19th, and then he'd have them well in advance, and I guess I'll do it that way. Prior to setting the preliminary examination, it's being a critical process, a couple of things that the court wants to do. Mr. McGowan, starting in case ending in 0979. Mr. McGowan, you are before the court on a felony complaint that alleges 5 different counts, excuse me, fleeing and eluding 4th degree, which is a felony punishable by up to 2 incarceration, $2,000 fine plus court costs. Count 2 is operating an unregistered vehicle, which is a misdemeanor, punishable by up to 90 days. Operating without security, which is a misdemeanor punishable with not more than 1 year or less than a $200 nor more than $500 fine plus court costs. Count 4, operating while license suspended, denied, and or revoked. That is a misdemeanor punishable by up to 93 days. $500 fine plus court costs, and your vehicle would be subject to mobilization. Count 5 is refusal to obey a lawful traffic order of a police officer. That's a misdemeanor punishable by up to 90 days, $100 fine plus court costs. Those events are alleged to have occurred on July 3rd, 2025, I-94 near Parker Road in Scioto Township. That is on the one case. On the other case, which is a 3-count complaint, that 3-count complaint alleges that on March 27, 2024, location of Dexter near Arcona in the city of Milan, Washtenaw County, state of Michigan, that you did operate a motor vehicle while intoxicated. That's a misdemeanor punishable by up to 93 days, $500 fine plus court costs. There is, however, a third offense notice which transforms this into a felony charge. It's punishable by up to $500 to $5,000 fine plus court costs, 1 to 5 years in jail, probation with 30 days or 1 year in jail, or at least 48 hours to be served consecutively, and 60 to 180 days community service. Any rehabilitative programs the court deems necessary. Court could order you to pay the cost of the prosecution, plus the cost of any emergency governmental services, and your vehicle would be subject to mobilization. Count 2 is operating while your driver's license was suspended, denied, and or revoked. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Count 3 is fine plus court costs. Ms. McGrew, I would just ask, do you still wish on representing yourself, sir?
Your Honor, I will. I have requested assistance given that I am incarcerated and I have no way to.
You wish to be represented by an attorney, sir?
I would like legal assistance.
What do you mean by that? Would you like to be
Well,
represented by?
I've called the
Well, Mr.
prosecutor.
McGrew, we go through this every time. So here's what I'm going to do. I'm going to advise you that there are great perils in representing oneself. I've told you about that before on numerous occasions. That I would treat you the same as I would treat anybody else. You would have to know the Michigan court rules. You'd have to know courtroom procedure, and that you would be treated the same, not any more favorably, not any worse, as you would go through these proceedings. If you wish to represent yourself, you may proceed with the court's admonishment. I've advised you as to the penalty, the charges, the maximum penalties. I will now ask you the question, and I'm not going to just keep going around and around in circles when I ask you this question. Do you wish to be represented by counsel? If you wish to be represented by counsel, this court will ensure that counsel is appointed to represent you.
If
that is a yes or no?
I would like legal assistance, yes, Your Honor.
I'm going to take that as your request for counsel, is how I'm going to take that. And so these two cases now become public defender cases.
Thank you, Judge. Torshio Fisa, Assistant Public Defender on behalf of the defendant. I believe Your Honor has already agreed to set it for examination.
I will set, he's asked for examination in the case, and so I will set these for preliminary examination.
Okay. Well, Your Honor, I would ask, given that one of these cases, in regards to the March 27, 2024 case, there is an undue delay. It's been over, I think, 390 some days since the warrant was requested, and this triggers due process violations under U.S. versus Levasco, People versus Bassard, People versus Rosengreen, and procedural unfairness, Sixth Amendment violations, and I do request that the prosecutor provide provide information in regards to the three-pronged test under People versus Hernandez, one of them First test being the explanation for the undue delay for 390 some days. The second part of that test being to prove that the delay was not deliberate. And then the third part of the delay or the prong test is to make sure that there was no undue burden on or prejudice on the defendant. And in that regards, Your Honor, I also am requesting that I do have due process 14th Amendment rights as well as 8th Amendment rights. And a lot of these are facially invalid. A lot of these charges are facially invalid. I'm just requesting that the court grant a personal reconnaissance on my behalf. And for both of these charges, being that we're looking at really just misdemeanors, $500 misdemeanors. So
I think he's requesting, Your Honor, amend his bond, and he's requesting the release, Your Honor, PR bond.
A response from the people regarding his bond.
People would ask the bond to continue, and he could also, I'm sure, fail to appear before judge's plays. So
Yes.
that warrant would also, with respect to the other, I'll wait. If there are pleadings filed by the public defender's office, our office will respond to that. And I guess my one remaining point would be, should, with the court's appointment to Eastern the Public Defender's Office, I will make sure that the digital discovery that I referenced is certified in the Public Defender's Office.
Yes.
Thank you, Judge. We will review that with our client once we receive it.
So he's asked for a preliminary examination, and I realize where this may be. My understanding is that he is still being held, regardless of what the bond would, in this case, he's being held without bond in Judge Slay's case.
That's my understanding.
That his bond has been denied, so.
That's what I
would
Mr. Choda said.
in any event, but also given the fact that one of the charges is the escape from lawful custody, that in and of itself, in this court's mind, makes the defendant a danger for a risk of flight. Also, the nature of the charges, the fleeing and eluding police officers, as well as the operating while intoxicated, now at least alleged his third time around. Also, this court's mind, the defendant, this court would consider a danger to the public. So the extent that he is asking that I modify his bond conditions in his bond in this case, that motion is denied. Bond will continue as it is.
Your Honor, I have a 14th Amendment due process to the presumption of innocence. And
I understand the presumption of innocence.
well, and a lot of these are facially invalid, Your Honor.
Excuse me?
A lot of these charges, especially the lawful custody, escape from lawful custody, it's facially invalid. I was at a hospital, not a jail.
If you were under the custody of the Washtenaw County Sheriff's
I was
Office,
not.
I understand.
I was not.
Or custody of.
I was dropped off at the hospital and they later tacked on
And
charges,
you know
just
what?
like the fleeing and
evidence
eluding
will
charge.
Not meet that out, and that if that's true, and the people can't sustain that element, then the charge will be dismissed. But I'm not dismissing it upon your representation today.
Thank you very much, Judge.
Preliminary examination in this matter will be set August 19th, 2025, 12 noon. That is before me on that date for both of these cases. I will apprise the parties also that one of the, I will call it one of the activities, and I think it is a maneuver to have the court do something that it normally would not do. The defendant has elected, and I will disclose it, to file a civil claim as against me and a slew of other parties.
Oh, yeah, in that regard, Your Honor,
Many of those, do not interrupt me. Including many that I don't even know the connection. Court has, this judge, upon receiving this, two things. I read through the complaint to determine whether or not it would on its face create a conflict with court. I consider it, quite frankly, to be frivolous. The complaint itself, do not see that as a necessity for me to recuse myself from this gentleman's proceedings, because I think that's precisely what he wants to have happen, and that is attempting to manipulate the system. He will be dealt with by me as I would deal with any other defendant, and so that is there. It has been turned over to the Office of General Counsel for Washtenaw County. They will deal with, for me, and as well as the others that I see that are listed there. They will deal with that. They have also filed, it appears, and again, this is all part of his, what I will call shenanigans to shape this. He has filed against people of individuals without specific reference in the Washtenaw County Prosecutor's Office. I don't, as I view what I read, would not consider that any jeopardy upon their objectivity in handling this case. So.
You're not aware that such note or such filings were being received by our office maybe yesterday. At this point, we continue to proceed with this case and until I did otherwise from the elected prosecutor.
can I speak on that note, Your Honor?
I will let you talk, but I'm not going to let you go on in some diatribe. I've got other things to do.
I've stood on my rights and I've stood on my beliefs this whole entire time, especially in the previous case, Your Honor. That complaint is well pleaded. It does affect multiple parties of this jurisdiction. Washtenaw County is a named party, and I do believe that my impartiality and bias will be affected here, as it was in the past before this complaint. And I do request a change of venue on that note for both these matters.
If you wish to raise change of venue, you may file that in writing, but to the extent you are.
All right, everyone, let's take a moment to break this case down from start to finish. Because what we just witnessed inside this courtroom is layered with legal maneuvers, high-stakes accusations, and more than a few dramatic twists. We started with Daniel McCoo standing before the court, facing a long list of charges: fleeing and eluding police, driving under suspension, operating an unregistered vehicle, operating while intoxicated with a prior record, and even escaping lawful custody. On paper, these charges range from misdemeanors with small fines all the way up to felonies carrying years in prison. Right away, you can see why this case matters. The outcome could determine whether Daniel walks away with minor penalties or faces years behind bars. Now let's talk strategy. From the very beginning, McCoo tried to punch holes in the prosecution's case. He claimed one charge, escape from custody, shouldn't even apply because he was being held in a hospital, not a jail. And legally speaking, that's an interesting argument. The statute requires lawful imprisonment, and he's betting the court won't see a hospital as confinement. Whether or not that argument succeeds is up to the preliminary exam, but it's the kind of technicality defense lawyers sometimes use to their advantage. Next, he pushed back on the driving charges. He demanded proof that his license was suspended and that he had been properly notified. He even challenged the prosecutor to
Court calls the case, People versus Lerone Kelsey.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Kelsey. I'm sorry.
And I should call this for the people.
He should be on. I texted him this morning. He said, I'm getting on now.
We don't have it.
Yeah, 2 minutes ago, he said heading on now.
That you were gonna ask, and then it was gonna get into a long conversation. Court calls case, People versus Whitney Mitchell.
As spells for the people. Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. Mitchell. State your name for the record.
Whitney Mitchell.
Thank you.
Your Honor, this was adjourned from last Wednesday when Ms. Mitchell was remanded. As the court knows, I requested that she stay out of custody so she can go to treatment that was kind of in process of being set up by the University of Michigan. I did want to provide the court an update. I've been fighting with University of Michigan records and HIPAA laws and all that good stuff over the last 5 business days. They won't tell me anything because of the HIPAA. So I haven't made much progress there regarding that appointment she had last week and the follow-up appointment. However, Ms. Mitchell and I have had multiple conversations since then. She did inform me that she was, and I got a little information about the program she was already set up in. There was outpatient treatment that she set up back in August. That is through the University of Michigan's addiction treatment program. She is also, they work it out with her work schedule because she works from 12 to 8. She would attend that treatment for 3 days a week from, I think you said 9 a.m. to 12. And she indicated that she didn't get really started in that program because she had to go file some paperwork through her job so she could have an hour missed and show up late because she was doing that program. She was behind on some bills and just didn't get that ball rolling. However, she was enrolled in that program. So today I would renew my request to release her. She is, if she's released, able to start that outpatient, from what you explained to me, outpatient program as soon as her boss signs off on that approval, that work exemption. She is very concerned about her losing her 2 jobs. She works at the University of Michigan full-time, 8 hours a day, 5 days a week, and then works 12 hours at Five Guys on the weekends from 8 to 8. She is concerned that if she loses her job, she will not have the insurance to cover her outpatient program that she did set up. So today we're requesting an adjournment of the pretrial and for the court to consider releasing her to that program. Again, I have not been able to get any further details. I even emailed the doctor directly and to see if they'd give me any information, but didn't get anywhere there. So again, we're asking for her release today.
Anything from the people?
Your Honor, as the court will recall, the last time that we were here, the court reviewed with the defendant her history of dilute and positive tests. I know the defendant has not had any violations on her scram tether at the time that we were here last. I don't know if it's still on or not, but I would ask that if any release, continue to include that scram tether. And if there is a continued pattern of dilute tests, I'm going to be requesting remand until trial. This is an OWI-7 offense. I'm very concerned for public safety, but I recognize that the defendant is somebody that needs to be rehabilitated, so that way the community can be safer from her. So I will leave it in the discretion of the court with the caveats of asking for continued electronic monitoring.
Anything you want to say?
Yes, last time you told me to think long and hard, and I've had 7 days to think long and hard, and this is not a game. I just want to get out and try to salvage my job and go to the 3 days a week treatment. And I apologize for not thinking, and I will have self-control and just go to work and do my drug test, come home.
The young lady on this side back, is she with you?
All 3 of them are with me.
Or who do I have?
My grandma, and that's my auntie.
Your grandmother showed up with you
Last time.
Last time.
Now it's my mom, my grandma, and my auntie, but I'm older than her. So it's like
I don't need to know that.
I'm older.
When I look at him, you look older than all. Yeah, I said it.
Oh.
You're gonna end up. Let me ask you this. Why do you think I locked you up?
BSing, me trying to beat around the bush. And like you said, 7 long days of being locked down for 23 hours. I thought about it. It's not worth it. You can literally lose everything at the drop of a dime.
Yeah. And you sat there. Not that people don't have answers for everything, but you had an answer and an excuse for everything that happened. And then you did the worst thing that you can possibly do with me. I don't know whether you knew it or not. And that is you try to use your child as a shield to stop something from happening.
That was stupid.
Yeah, you were.
I'm not hurting nobody but my family and my child by doing this.
Your grandmother was with you last time, and now the other 2 ladies that come down try to figure out what they're going to figure out what to do. Mom, grandma, you want to say anything? Who are you, ma'am? Either one of you, whoever wants to say something to me.
My mom probably, my grandma's probably too nervous.
I think grandma last time mentioned she can't hear very well.
Oh, she can. Okay.
She might,
Can we get her the? Does that help, Grandma? Yeah. Okay. Was there anything you wanted to tell me?
Well, I think that we need to go to treatment, to rehab. I think she should be in a treatment and stay and continue to go to a treatment.
Okay. All right. Thank you. Mom, was there something you wanted to say? Is that Mom?
I concur with my mother. Been working with my daughter a long time. I agree she needs help. I've been working on it, calling, so whether through the university or I have to come out my pocket to find her somewhere to go. I'm gonna committed to doing that because she's the only child that I have. So, if you give her a chance, get rid of myself on the line. I know that's a lot. But I'm not going to give up. All I got.
All right. Okay, thank you. Huh?
Said the same thing you said last week. I watched the entire thing on YouTube. Sorry, I wasn't able to come, but I work.
No, it's okay. It's all right.
But we've been having discussions for a long time, so you were right. She's been lying a long time. But now that crap has hit the fan, she sees how it affects everybody, not only her. Hopefully, she'll follow through what she said, and we can start life. She started great.
All right. Thank you. Somehow, although your mom wasn't here, somehow, when I looked at your grandmother, I knew what I was telling you, you had already been told before, probably repeatedly. So I'm not really clear, although I wasn't sure of that, I'm not really clear when you showed up here, why you decided that you thought it was going to work. I mean, I know I look stupid, but I'm really not. How many times were you testing a week?
Twice a week.
And at the outpatient program, she will be tested 3 times a week there as well.
Yep, 3 times a week.
Here's what I'm gonna do. I'm gonna let you know I'm doing this in a lot of ways for your grandmother and your mother. I hear your mother very clearly. She's been trying. She's not going to give up on you. So I don't know them, but they seem like 2 very dear people. So if you let them down, fair warning, if you don't think I'm real, you'll find out. If you let them down, I'm sending you, and there's not going to be anything you're going to say to me. Are we clear?
Yes, Your Honor.
So what I will do is I'll adjourn this to the 5th of November, 2025 at 9. I'll set your bond at a personal recognizance. Your testing at community corrections will increase to 3 times per week. I'll take a look at that after you're enrolled in some type of treatment program and where that's going as to whether or not I'm going to let you test there and not test here, but I certainly want to. So you could potentially do 5, you could potentially be testing every day.
It's fine. I'm all y'all gonna get from me is juice and water. I'm not, yeah, this is serious. I need to keep my job and keep my place, and I'm tired of
You
hurting
know what?
them.
You keep talking about your job and your place. Here's what the real issue is and what your mother is trying to tell you. You need to keep your life. It isn't about the job. It's not about where you're living. It's not about any of that. It's about just living. Did you hear the last thing your mother said?
She's not giving up on me.
She's not giving up on you, but she wants you to kind of work through this so you can have a life.
Yeah, it's not the life I've been living. It's really not a life.
No, it's not. And the problem is, and your mom knows this and grandma knows this, if you kept along the same path, you're going to end up dead. The only thing that they're going to be celebrating is your life at some homecoming ceremony or homegoing ceremony or funeral. And you need to understand it. That's how serious it is. There's not really a monetary value that you're trying to place on it. It isn't about that. Anything further?
Nothing further, Your Honor.
Did you put the script?
Are you on the scram now?
Yes, Your Honor.
All right, that will continue.
Thank
She's
you.
not-
Yeah.
Yeah, okay, thank you.
Thank you.
Thank you, ladies, for coming down. Do appreciate it. Court calls the case of the people versus Jennifer Galara.
Actually felt this with people.
Good morning, Your Honor. Attorney Amber Lee, P 84377, appearing on behalf of Ms. Galara, who appears via Zoom. Ms. Galara, can you unmute and say your full name for the record, please?
Jennifer Galara.
Thank you. All right. Okay, what are we doing on this count?
Your Honor, we did submit a reduction request to the prosecutor's office. That was just sent over this week, so I don't believe they've had time to review that yet, Your Honor. So we would request a final pretrial. There should be 2 cases up for her, so just a final pretrial for those 2 cases, Your Honor.
Well, if I give a final pretrial, you're not going to get a date until December. So you just want me to adjourn the pretrial out for their consideration?
Yes, Your Honor.
All right.
And that's correct, Your Honor. It looks like I got that request yesterday afternoon, so I have not had a chance to look at it yet.
Okay, November 5th, will that work?
That's perfect. Thanks, Your Honor.
All right, November 5th, 2025, 9 a.m. Where's your invite indicates?
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, ma'am. Court calls case of the people versus Brandon Bileski.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Bileski. State your name for the record.
Brandon Bilski.
Yeah, I know. We did that the last time, I think. All right.
Your Honor, today's the day and time set for sentencing. We did review the pre-sentence report and don't have any material changes, additions, or deletions. And we do ask that you adopt probation's recommendation.
Sir, is there anything you'd like to say before I impose sentence?
Not exactly. I would be very, I'd appreciate the opportunity to, fulfill this and, help me turn my life around and be a better, better father and be there with my kids and be clean. Just appreciate the opportunity to show you that I can do that.
Let's see what you can do.
Okay.
Sentence of the court to place you on probation for a period of 12 months. You're to pay $555 fines and costs, $360 probation oversight fees. I'll make that'll be on a payment plan as arranged by probation because you've got to get yourself established once you do get out, right? No use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a substance abuse assessment, follow all treatment recommendations with status reports to probation. I'm sorry, my label was cut out. You're to complete 25 hours of community service as directed by probation. You're to maintain employment with proof to probation. I'll order 365 days of jail credit, 60 that you serve. The balance is suspended. Okay, thank you. Got it. They are. Okay. Court does recall the case of People versus Lerone Kelsey.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Kelsey. Mr. Kelsey, state your name for the record.
Lerone Kelsey.
We are requesting an adjournment. Mr. Kelsey is going into the sobriety court in 36th District Court.
Got it.
So I'm gonna try to work with the people to see if this case can be transferred as he's doing that program.
Okay. Is the 5th going to be enough time or you need more time, you think?
I think probably more time. He's being officially welcomed into the program on the 29th.
Of this month?
Yes,
Got
and then the program has to do their screening and all that logistical stuff.
My notes indicate he has a case in Roseville as well, so that I think is what he's getting into sobriety court for, another OWI case. So
got it.
it might benefit us to have a little bit of time to see how he's doing.
Last date in November.
19th.
Yes. All right, I'll adjourn it to November 19th, 2025, 9 a.m. If it looks like you don't have enough information, then I certainly will stick to adjourn that as well.
Thank you.
All right, thank you. Thank you, sir. Court does call the case, People versus Roman Hop. Why do I get nervous that Constantino's case hasn't been called?
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Hopp. State your name for the record, please.
Thank you. Go ahead.
Your Honor, today is the date and time set for sentencing. I do want to sincerely thank Ms. Pollara on the record for getting this done because I sent her a pleading email and she really made things happen.
I told her not to do it. I said she didn't have to do it. You went in there pleading.
I pled, yes.
And then I get informed yesterday that Teresa went down and did it, being the dedicated employee and probation officer that she is.
Yeah, I saw her we were both at the jail at the same time, so.
And she didn't have to be.
No, she did not. So I really appreciate that.
Claire, we're gonna have to talk. You gotta be like me, not so nice.
And Mr. Hopp really appreciates it too, I know.
All right.
So
I
we,
had a feeling, by the way, that it was gonna go that way. But I wasn't gonna put the stress on her. You did. Good job. All right, go ahead.
well, I owe her 1,000 favors, so we'll just add this one to the tab. Your Honor, I'm asking that the court adopt the recommendation. I did review it with Mr. Hop. We reviewed the pre-sentence report. We don't have any changes.
All right. Mr. Hop, is there anything you want to tell me?
No.
All right. We got you done now, right? Ms. Blair?
Your Honor, there was one thing that I did not include in my recommendation that I would like to ask the court to add. I would like to have Mr. Hop ordered to report to me in person this Friday at 11 a.m.
This Friday is the
24th.
24th.
And I will say, Mr. Hop may still be in custody for the next couple of days. He has $100 bond on that other case. I let the attorneys over there know, so they might be doing something by writing, but also he has court with Judge Hamoud on Monday. So we're hoping, if not by the next couple of days, by Monday, that bond should be,
So if he doesn't have me released, I would ask that he contact me immediately if I'm released to get him.
All right. Okay, you understand that?
Yes.
All right. And you said the 24th at 11 a.m.
11 a.m.
I don't know. And you said you had nothing to say, Mr.
No.
Correct. All right. It's a sentence of the court. I'll place you on 18 months probation. You're to pay $555 fines and court costs, $550 probation oversight fees. You're not working when you're working when you're out, right? But
I wasn't working at the time.
all right.
I have a job opportunity lined up, hopefully.
I don't know how that happens in jail, but whatever. All right, a payment plan is arranged by probation. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the Beyond Barriers program. You are to comply with mental health services through CMH, including medication protocol. No contact with Faith, Ron, or is it
Stefanovich.
Christoph Hobb? You understand that? You're not to contact them directly or indirectly.
They're dead to me.
No going to the Deke Avenue address in Ann Arbor or the Jefferson Street address in Ypsilanti. There's to be no assaultive, threatening, or intimidating behavior. You're not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. You're to maintain employment with proof to probation. I will order 365 days in jail, credit 78 days served, the balance is suspended. I will additionally order that you're to report to probation in person on November 24th, 2025 at 11 a.m. If you are not released, then you are to contact immediately upon your release the probation department. You understand that, sir?
Yes.
All right. Thank you.
thank you.
Hello, my name is Alejandra Cantu, and I am one of the franchisees in San Antonio. I have a business partner, Lily Lezama, and we started.
Huh? Yeah, it's a lot of cases.
Yes.
That's one of them's constant. All right, fine. Court calls the cases of the people versus Jessica Yoder.
Oh, okay, never mind. Christina Costantino appearing on behalf of Miss Yoder in case number ending in 1282.
Assistant Public Defender Lauren Kearney on behalf of Ms. Yoder on the other two cases.
And Miss Yoder, can you state your name for the record?
Jessica Yoder.
Thanks.
I'm just saying. All right, go ahead.
Judge, this is the date and time set for sentencing. We did receive and review a copy of the pre-sentence investigation report. We do find it to be factually accurate and correct.
Same.
Okay. Yoder, anything you want to tell me before I impose sentence?
No, nope. I'm just glad this is all done and I'm ready to go to rehab.
We'll miss you.
I won't miss this court.
Wow.
Well, at least the
Well,
court date.
no, that hurt.
I won't miss coming up here every 2 weeks.
Wow.
That she would not be back.
No, I will not be back.
She did.
She made that promise.
I'm not.
Really?
Yes.
She promised.
Yes,
Promise
I will not
that?
be back. I'm done. All my COs are retiring.
You know,
and I'm
I
retiring with them.
remember.
I said all my COs are retiring and I'm retiring with them.
Okay. Great.
Yeah, there is.
Well, you can always come in because I'll just say this. You started out when the cases were first, you were just an angry, bitter person when these cases first started. You were mad at the world. You were apparently mad at me. I didn't care, but whatever. And you just thought the whole world everybody was just against you.
Yep.
And at some point, as these cases went on, your personality started to come out, which is not a bad thing. I mean, it started to come out. You would actually come out of the back. You would actually be smiling at times. And I realized, yeah, there's a human being there. If she can just get some things together, she's going to do well. So I am hoping by all of this that part of it, while it's been sort of arduous and a long task, it works out because you were trying your best to escape any type of treatment or anything. Yeah. Not because you didn't need it, but because you didn't want to do any of the hard work.
No, I didn't want to do anything.
Huh?
I didn't want to do anything.
Yeah, nothing. And you let me know that. But I can hold you long enough till you change your mind. All right. Okay. On the case ending in 1283, sentence of the court, $125 statutory fee, 365 days in jail, credit 79 served. To serve the balance, I'll allow release to residential treatment. If you fail to complete treatment, you must serve the balance of that sentence. Understood?
Yes.
On the case ending in 1137, $125 statutory fee, 93 days in jail, credit 93 served. On the case ending in 1282, on count 1, the receipt and concealment of stolen property, $125 statutory fee, 365 days in jail, credit 79 served. If you're to serve the balance, I will allow release to residential treatment. If you fail to complete treatment, then you must serve the balance of that sentence. On count 2, the attempted R&O, $50 statutory fee, 365 days in jail, credit 79. The year to serve the balance will allow release to residential treatment. If you fail to complete the treatment, you must serve the balance of that.
Yeah.
All right. Thank you.
Thank you.
Ms. Yoder, sincerely, good luck to you.
Thank you.
Court does call the case of the people versus Min Kim.
Good afternoon, Your Honor. Mark Chiaz on behalf of Min Kyu Kim, who stands to my right.
Your name, sir?
My name is Min Gyu Kim.
All right.
Your Honor, this is day and time set for a sentencing on a drunk driving case. Again, Mr. Kim did do the alcohol screening assessment report. I've reviewed that with him. We've also reviewed the recommendation from probation agent Teresa Pillar. With regards to the assessment, Your Honor, again, no factual errors. I do take issue with the one conclusion where it stated the client's responses did not acknowledge the consequences of this arrest. Again, Mr. Kim acknowledged this is a very serious matter. Again, the moment that he was placed in handcuffs, he understands that he could have harmed a member of the public or himself. Furthermore, Mr. Kim understands that this could have a tremendous impact on his life. Mr. Kim currently owns several restaurants in the area. Some of these restaurants have liquor licenses, and with this conviction, he could be forced to sell some of those businesses. So again, he understands the consequences of this. With regards to the sentence, Your Honor, or the recommendation, I'm sorry. With regards to the recommendation, again, we see that it seems appropriate. I would just ask with regards to the attendance to AA meetings 1 time per week for 6 months. Mr. Kim, again, being the owner of several restaurants, works in excess of 80 hours per week, Your Honor. Again, these restaurants are open from typically, some of them early in the morning, but most of them from 11 or 12 to later in the evening. In lieu of the AA, we would like to see if the court would give them some type of community service that would be more maybe accommodating to the schedule.
Sir, is there anything you want to say before I impose sentence?
I'll just like to say that I really do. That night I could have impacted someone else's life forever and impacted my own life forever. And I do think about that very often. I will be responsible going forward. Well, I have been as well, but yes.
Court does acknowledge this is not a serious misdemeanor as defined by statute. However, the court does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. Specifically, the alcohol screening and assessment identifies the benefit of early intervention education, attendance at AA meetings for 6 months, and continued abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, to monitor compliance with recommended treatment. Is therefore the sentence of the court. I'll place you on probation for a period of 9 months. You're to pay $855 fines and costs, $100 prosecution recovery costs, $100 police agency recovery costs, and $270 probation oversight fees. When can that be paid?
I'll pay it today.
Thank you. Pay that today. There's to be no use of any alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the alcohol highway safety education program. I am going to order the 1A meeting per week for a period of 6 months with monthly verification to probation. I think that in this case, it is appropriate given my review of the screening and assessment, and also one has to realize the defendant was a 0.181, at least according to my record. So I am going to order that. You are to provide proof of victim's impact dental attendance to probation. The sober link will continue for an additional 30 days in lieu of 4 days in jail. I'll order 93 days in jail. Credit 1, the balance. Credit 1 day served, the balance is suspended. Thank you.
Thank you. Good day.
You too.
Imagine being able to build an app with your name on it.
Court calls the case, People versus Quincy Jones.
Public Defender Natalie Page for Mr. Jones. Your Honor, who I do not believe is present.
Yeah.
I do not have an explanation for the failure to be here. Both myself personally, as well as my intern, on separate occasions have tried to reach out to him. We both voicemails. We did not hear back, and I do not have a further explanation for his failure to appear.
And Teresa Claire on behalf of probation. Your Honor, Mr. Jones was scheduled before the court today for a violation of probation. He is non-compliant with any of the terms ordered by this court. Given that and his non-appearance, probation is requesting a bench warrant.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000 cash surety. That warrant will issue immediately.
Thank you.
Court does call the case of the People versus Alexis Berry.
Assistant Public Defender Natalie Pate with and on behalf of Alexis Berry, who is present via Zoom. Can you please state your name for the court?
Alexis Berry.
Thank you, Your Honor. I have had the opportunity to review the assessment, and I did discuss with Ms. Beery her progress report in the late blows and the order to comply, and she does understand the importance of continuing to blow in the sober link within the appropriate time windows. As to the recommendation from probation as to her sentence, we would ask the court to adopt that. The only request I would make as to that would be that Ms. Berry be allowed to pay the fines or the monetary components of the sentence on a payment plan as arranged by probation. She is currently working, and as the court is aware, she is already on probation to this court for a related case, but separate, that she is in compliance with. So I would ask that the court would allow her to pay on a payment plan, but otherwise would ask the court
Does
to
she have
adopt it.
anything to put forth before I?
I don't know, Ms. Berry, is there anything to pay today in this case? Or were
Yeah,
you
I was just
requesting-
gonna say, for this case, I was gonna pay $100 today.
Okay. All right, Ms. Berry, is there anything you want to say before I impose sentence?
I just really want to say, this has been a lot, but it has taught me a lot. I definitely know that I did wrong that night, and it definitely has helped me a lot. Even like the anger management classes, I actually enjoy them. Sometimes you learn that even though like you made a decision, you made that decision, you got to go through life with it. And so I'm just happy to be here, and I'm happy to be doing better for myself, and I'm super committed to changing and keep doing what I'm doing and stay compliant with probation.
The court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening assessment identifies the benefit of outpatient counseling, abstinence at or attendance at AA meetings, and continued abstinence from alcohol. Therefore, the court will follow the recommendation of probation with the stated of a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and monitor compliance of recommended treatment. Therefore, the sentence of the court, you're placed on probation for a period of 12 months. You're to pay $855 fines and court cost, $100 prosecution recovery cost, $100 police agency recovery cost. We are waiving the probation oversight fees. You are to pay $100 today on this case, and then a payment plan set up by probation that would be consistent with her other matter.
Okay.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete the drug and alcohol awareness class or comparable class. You're to do that within the next 60 days. You're to attend one A meeting per week with proof to probation. You're to provide proof of victims' impact panel attendance to probation. I'll continue to sober link for an additional 30 days in lieu of 3 days in jail. I will order 93 days in jail. Credit 2. The balance is suspended. Thank you.
Thank you, Your Honor.
Thank you, Ms. Berry.
Thank you.
Court does call the case, People versus Daniel Bowe.
Call dispatch for Lauren Chet on stage.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Bowe. Mr. Bowe, state your name for the record.
Daniel Bowe.
All right, today's the date and time set for sentencing. We did review the pre-sentence report and don't have any changes. We ask that you adopt the recommendation.
Mr. Bowe, anything you want to say before I impose sentence?
No, Your Honor.
All right. Sentence of the court, $500 fines and court costs. When can you get that paid?
Within 90 days.
Do you have anything today?
I got at least $50 on me. I know that.
Pay $50 today, and then I'll make this due and payable. Won't quite get to 60 days, but I'll make the balance payable by December 31st, 2025.
Thank you, Your Honor.
I'll order 365 days in jail. Credit 1, the balance is suspended. Thank you.
Thank you.
Yep. Court does call the case, People versus Rebecca Schilling.
It's the public defender Natalie Pate for Ms. Schilling, who I don't know if she's present, Your Honor. I know she's not physically present in the courtroom. I don't know if she's on Zoom. She's not.
She's not in Zoom.
Teresa Claire on behalf of probation, Your Honor, Ms. Schilling was scheduled before the court today for a violation of probation. She is not compliant with terms ordered by this court. Given that she is also not here, probation is requesting a bench warrant.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000 of cash surety that will issue immediately. Thank you. Court does call the case of the people versus John Funch.
Yeah, this is John Punch.
Good afternoon, Mr. Public Defender, Mr. Funch. Your Honor, today's date and time set for sentencing. We do ask that you adopt the recommendation, and we did read the pre-sentence report and find it accurate.
All right. Sir, is there anything you want to say before I impose sentence?
Yeah, I'm sorry I did this. It was stupid and it will not happen again. I do apologize to you and the court.
Sentence of the court, $480 fines and court costs. When can you pay that, sir?
If you can give me 2 weeks, that'll be sufficient.
All right. Pay it then by December or November 7th.
Okay.
2025. I'll order 93 days in jail. Credit 1, balance suspended. All right. Thank you.
Have a good day.
You too. Court calls the case. People versus Jennifer Gray.
Assistant Public Defender Natalie Gray is, Your Honor,
I don't see her.
So, Your Honor, the only explanation I can offer for failure to appear is that we've been reaching out to her this week, and I personally tried multiple times as well. Every time I try to reach her, I immediately receive a message that says voicemail box not set up yet. I did send her a text with a Zoom information request for a call, but didn't hear back. I do not have an email address for her. I do know she is 70 years old. I don't have any further explanation outside of that in the voicemail box situation. For her failure to appear, I really can't represent where she is, but for the record, I request an adjournment.
So when was the last time you had any contact with her?
I have not, Your Honor. I was not the attorney who handled her plea at the PCC stage.
Got it.
And I guess what I can say is there was a note in the file by a previous attorney that Ms. Gray typically shows up to court. However, there were a couple of times where she showed up to court without speaking to us ahead of time. I was hoping and half expecting that might happen today, however, did not. I don't have a further explanation for her failure to appear.
I'm Teresa Claire on behalf of probation. Your Honor, I cannot explain why Ms. Gray is not here. I know that I have spoken with her. We did adjourn her sentencing because she was hospitalized. She had a medical issue. And I know that she was hospitalized for about 17 days. She does live in Houghton Lake. And she typically drives down here for court hearings because she's not very good with Zoom. And so, I can't explain it. I would not be opposed if the court is willing to do an adjournment.
That's what I was leaning towards. So I'll adjourn this. The 12th is my next sentencing.
Yes.
So what I will do is I'll adjourn this out to November 12th, 2025, 9 a.m. Let's see if we can figure out what's going on.
Thank you very much.
Find your perfect tax expert, whatever your tax situation might be.
Court does call the case people versus Anthony Williams.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Williams. Your Honor, I did attempt to contact Mr. Williams multiple times. He's not present in the courtroom. I have no explanation for his failure to appear.
And Teresa Claire on behalf of probation. Your Honor, Mr. Williams was scheduled before the court today for a violation of probation. He is not compliant with the terms ordered by the court. Given he is also not here, probation is requesting a bench warrant.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $25,000 cash surety. That warrant will issue immediately. Court calls case people versus Jeremy Huber.
Assistant Public Defender Natalie Pate with it on behalf of Mr. Huber, who is present via Zoom. Sir, can you please unmute and state your name for the court? Mr. Huber, I think you accidentally hit the flip your camera button instead of the microphone.
I did. I did. Okay. There we are.
Okay, state your name, sir.
Jeremy Huber.
Okay.
Teresa Claire on behalf of probation. Your Honor, Mr. Huber is scheduled before the court today for a violation of probation hearing. As the court can see, this case is very old. It's from 2008. Mr. Huber is in violation of the terms ordered by the court in that he owes a balance of $3,310. Actually, Your Honor, I take that back. His balance now is $3,000. He did make the $310 payment today that probation is recommending. He had failed to report to probation as directed. There was no proof that he completed treatment or the terms that was ordered by this court. He also did pick up a new criminal conviction, a controlled substance, deliver manufacturer ×2. He was sentenced to prison on that. He went to boot camp or the SAI program. He was in custody for that program July 23rd of 25. I'm sorry, of 24.
24.
Yeah. Through March. Given, and while he was in prison, he participated in substance abuse programming and completed that. He is now on parole supervision and will remain on parole supervision until September. At this time, given the age of the case and his jail time that he served and his treatment completion, probation is recommending 240 days in jail with credit for 240 days served for the violations to date, that the court waive the remaining terms, accept his financial obligations, and discharge him from probation without improvement. Additionally, probation is recommending the 310 payment, which he did make this morning, and refer the remaining balance to collections.
Thank you, Your Honor. I did discuss this with Mr. Huber. He does admit to the violations of probation and asked that the court adopt probation's recommendation. And I did, not that it matters, but I did confirm too that he did pay that 310 already this morning.
All right, Mr. Huber, anything you want to tell the court?
Your Honor, good morning. I went to the Harbor Hall Treatment Center in Petoskey, completed 30 days there and went through a 1016 treatment program, completed that there also, Your Honor.
Okay. All right. Very good. What I will do is kind of close this out for you. 240 days in jail, credit 240 days served for the violations to date. I'm going to waive the remaining terms, accept the financial obligations. I'll discharge you from probation without improvement. You did pay the $310 that has been paid. The remaining balance I will refer to collections. All right, sir?
Thank you, Your Honor.
Thank you. Good luck to you.
Thank you.
Court does call the case, People versus Rex Jenkins.
The Assistant Public Defender Natalie Pate for Mr. Jenkins, who I don't know if he was present, Your Honor. He is incarcerated in Ohio, to my understanding.
Really?
He is, Your Honor. I did confirm that he is serving time in the Northeast Ohio Correctional Facility.
So what do we want to do on this then?
Your Honor, I guess at this point, I would ask if we could just adjourn it and maybe a writ can be done so they can have been present. There is restitution.
That's
an issue. I have spoken with family members who indicated that they could have that part taken care of. So that's part of my recommendation, that be taken care of. And so I factored that in my recommendation. So if we could just do a short adjournment and I can try to get.
All right, I'll adjourn it to November 12th, 2025, 9 a.m.
To be honest, sometimes I actually have no idea what's going on.
Thank you, Your Honor.
All right, thank you. Court does call the case, People versus Abdullah Kafaji.
Sorry.
Oh, there he is.
An Assistant Public Defender Natalie Pate with and on behalf of Mr. Kafaji, who is present via Zoom. Sir, can you please state your name for the court? Oh, and also remove your hat for court, please.
Abdullah Al-Kafaji.
I can't even.
I think that, yeah, that's a baseball hat. He needs to take it off. It's not what I thought it was.
Sorry?
Your counsel asked you to remove your hat. You're in a court proceeding.
Okay, I'm sorry.
Thank
about
you.
that. Sorry,
Thank
good
you.
afternoon, Your Honor.
Good afternoon.
Thank you, Your Honor. Today is the date and time. Excuse me, again, set for sentencing. I have had the opportunity to review both the assessment and then discuss and review the recommendation for sentencing with my client. We are asking that the court adopt the recommendation. And I do just want to add, working with Mr. Kafaji has been very, very good. He's been very communicative with me, the way he handles his responsibilities. And I know he's been very busy. He works a couple jobs right now. He has a lot on his plate, but not only has he been very responsible and communicative with me, he's been frankly a pleasure to work with. So I did want to say that on his behalf, but ultimately we are requesting that the court adopt probation's recommendation.
All right. Sir, anything you want me to say before I want to say to me before I impose sentence?
Yeah, I just want to say, I'm sorry for the choice I made, Your Honor. It wasn't the right choice, and I know I disappointed a lot of people in my life, and I should have not done that because I was putting other people's life in danger as well as mine. And I also do want to thank you again, and I do want to thank Public Defender Natalie because she's also helped me a lot through this. So I just want to thank her again. So thank you guys. I appreciate it. And yeah.
Okay. The court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening assessment identifies the benefit of alcohol education, attendance at AA meetings for 60 days, and continued abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. To sentence of the court, I'll place you on probation for a period of 9 months. You're to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $270 probation oversight fees. When can you get that paid, sir?
To be honest, Your Honor, I kind of have a lot to pay right now on my place. So can I get on a payment plan or something? Because
do you have anything you can get paid on this today?
No, Your Honor. Sorry about that.
We'll do a payment plan as arranged by probation, but don't have them bring you back in here because you haven't paid. You need to talk with them and get that arranged. Do you understand that?
Sounds good.
There's to be no use of alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as requested by probation. You are to complete the alcohol highway safety education program. You're to attend 1 AA meeting per week for a period of 60 days with monthly verification to probation. You're to provide proof of victims impact panel attendance to probation. I will at this time discontinue the sober link. I'll order 93 days in jail. Credit 1, the balance is suspended.
Okay, thank you so much, Your Honor.
All right.
Your Honor.
Thank you.
Thank you, Mr. Kafaji.
Thank you, Natalie. Have a good one. Thank you, guys.
Scribe makes step-by-step guides for any process.
Court does call the case, People versus Tierra Peters.
I apologize for that, Your Honor. Assistant Public Defender Natalie Pate with and on behalf of Ms. Peterson, who is present via Zoom. Ma'am, can you please unmute and state your name for the court?
Yes, Tyra Peterson.
Thank you, Your Honor. Today's the date and time set for sentencing. I have had the opportunity to review both the pre-sentence investigation report and recommendation with Ms. Peterson. We have no changes or corrections to the report. And as to the recommendation, we are asking that the court adopt it. I did speak regarding that $500 payment, when she could pay that. Ms. Peterson is, she did, as Your Honor, of course, has read the report, does receive some government assistance and does have a young child. She is asking if the court would allow her to make that payment in full by February. So I would be making that request if she'd be given that time to pay that.
All right. Ma'am, is there anything you want to say to the court before I do impose sentence?
Oh, no, sir.
Sentence of the court, $500 fines and court costs. That's to be paid by February 28, 2026. 365 days in jail. Credit to the balance is suspended. Thank you.
I'm really sorry, Your Honor. What was that pay by date you gave?
Really, you
I
want me
didn't
to say it again out loud?
Yes,
Never have done that before.
I know. I'm sorry.
Now
I
you want me
completely,
to repeat it?
Yes, because I did
No,
write it
I
down.
think
It's
you
my
just want me to repeat it so that when somebody else comes up here, you can try to throw that in my face. You want me to just.
No, I'd actually do it the opposite way if I was trying to be.
Miss Peterson,
Yes.
did you get the date?
Yes, I did.
Can you text
So,
me,
no,
Miss
so
Peterson?
we got it. We don't need you. Okay, I'll say it out loud. February 28, 2026.
I feel really bad I missed it. That's my sister's birthday.
Well, you should feel bad because you asked me for February.
Sorry.
Miss Peterson, didn't she?
Yeah.
Yeah, and then what date? She just wanted me to say it out loud again. Anyway, okay, that's fine.
Thanks, Miss Peterson.
Thank
Miss
you.
Peterson, you take care of yourself.
You too. Thank you so much.
Court does call the case. People versus Mira South.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Miss South, South State.
Really? No, say that 10 times. No, go ahead.
South State.
Myra South.
Thank you.
Thank you. Your Honor, today's the date and time set for sentencing. However, Ms. South did not complete her PSI appointment. I think honestly, it was
Ma'am.
Oh, so sorry. I apologize.
the attorney at PCC. I don't think this information was really explained to her fully, whoever that was, but
Whoever that was, you mean under the bus you just drove? Go ahead.
additionally, Miss South.
I don't know who I hit. Whatever. Go ahead.
I really don't know who it was.
No,
so
no,
it's
I know.
anonymous person to me. Miss South's phone was stolen a few weeks ago. So when I tried to get in touch with her and Miss Pilar tried to get in touch with her, we could not do so because her phone was stolen. She also can't access her email. So we've had no contact with her, but she did
Sounds
show
like
up
a bad
today.
country song, but go ahead.
Terrible. Terrible. Okay.
So we did speak with Miss Pilara. I think the plan is to complete it today, actually, because Miss South works 2 jobs, and she took the rest of the day off to be here in court. So I'd ask that the court adjourn the sentencing and consider waiving the re-referral fee, given all of that.
Really?
I will say Miss South during this instance was homeless. She's now working a job overnight and then works another job during the day.
That's why I don't do nice things. Go ahead.
She's really trying to, make all of this work. It seems like she's working really hard at that. So I'd ask the court to consider that.
So why don't we get the 75 to be paid by the person who ran the bus over? if they're the reason. Does that make sense?
I can't sign them up for that. I can't sign that up for them. I can't sign them up for that. I'll pay it. Maybe. My husband wouldn't be happy, but.
I'll re-refer to defendant to probation for a PSI. Said she can do it today, or this is set for Friday, but you're going to try to do it today.
Your Honor, I did indicate to her that I would do it as soon as we're done with court today.
Wow.
I know, she got lucky.
I mean, anyway, never mind. Wow, everybody's being so kind today.
Thank you.
I'll order that it's set for the 24th at 1 p.m., but if you guys get it done today, we're good in person. I'll adjourn our sentencing to November 12th, 2025, 9 a.m. I'll wait during 75. Whoa, don't look like you did anything. Wait, what?
Thank you. I feel happy with that. My one good deed. Thank you.
Okay, you felt happy, but you didn't have to go, yeah.
elect quorum.
Like you just won the national championship or something. Fine, all right.
Thank you.
Thank you, ma'am.
Get that to her, and then I'll see you 1:30. Oh, yeah, thank you so much.
He hasn't signed in.
All right. Court does call the case People versus Robert Greenshields.
Good morning, Rob Jacob on behalf of Mr. Greenshield.
I'm gonna reaffirm the county jail up there did not sign in.
Okay.
But those are all the people with her?
That's it for today, ladies and gentlemen. Like I said, I am so sorry I was late, but I had to wait for the office to open so I can pay my rent. And please pray for me. It's been 3 weeks since I've smoked a cigarette. I think I'm doing all right. I think the hard part is over. I think I got through the hard part. Really don't desire it. I mean, I want one, but I know what happens if I smoke one. But, you know, just pray for me. And of course, you know routine, guys. If you like this content, or any content that I put on this channel, please do me a big favor and subscribe to this channel if you're not subscribed and help this channel grow. And by all means, please, please, please share out my live streams out on the interwebs. Let people know that this channel is here and what we are doing on this channel. Let's grow this channel. Let's get up past 500 subscribers before the end of 2026. I know we can do it. I know we can do it. But that's it for today, ladies and gentlemen. Ta-ta and ciao-ciao. I will see you guys on the next one. Have a good evening and try to behave yourselves.
Give up on this heart of mine. Put it back together every single time. Fix it all, fixing your album, standing tall, tall. To all you do, from the highest peak, I can see it through. With your care and touch, everything's okay.